Act.
Chair.
The Honourable Minister.
Mr. Chair, I just wanted to take a quick call really to address some of the issues that have been raised and indeed address the SOP that's been tabled under the name of Pēni Henare. I think it's appropriate to do so tonight, in particular as we sit around part 5. But if I can just address one or two of the matters that were raised by members. Just to say again, a kaiwhakahaere is needed only if there is no governance body in place to implement and not make owner decisions to sell if they meet the 75% threshold. That's the first point. That's important just to set that out and say it absolutely clearly. And that leads on to the issue that the member Pēni Henare has in his SOP. And I'd suggest to the House that the amendment proposed in the SOP is actually unnecessary because the bill already makes discretionary provisions for the owners to be kept informed. And I refer members to clause 191, in particular bracket 2. It sets out there it sets out the responsibilities of kaiwhakahaere. Under clause 2, a kaiwhakahaere appointed for the purposes blah blah blah, consult with the owners about actions the kaiwhakahaere proposes to take on the owner's behalf and keep the owners informed about the actions the kaiwhakahaere has taken. You can read the rest. Pretty much it's setting out very clearly what kaiwhakahaere can do and covers off those issues that the member Pēni Henare raises. If I can go to clause 197, Mr. Chair, and again it sets out what the court may require a kaiwhakahaere to report to owners. It basically addresses the issues that the member raises. It already gives the Māori Land Court the power to direct the calling of a meeting of owners at any time and to direct the kaiwhakahaere to report to the owners on matters specified in 196, which is obviously the clause ahead of it. In terms of addressing the issues raised by Pēni Henare, I believe that those issues are already covered within the bill, and therefore we'll be voting accordingly and not to support that amendment. Adrian Rudolph raised in 156, I think it was, bracket 2, an issue about beneficial owners, and just to advise him that under the current Act, the owners are the beneficial owners, and the trusts and corporations are the legal... Sorry, start again. Under the current Act, the owners are the beneficial owners and the trusts and corporations are the legal owners. This is the same under the current bill, under this bill, and allows the governance bodies to manage the land effectively for the owners. There's the element of difference between those two definitions. The beneficial owners have the benefits of ownership and the legal owners have the responsibilities of ownership. So that, I hope, addresses the issues raised by the member for Te Taihau Haere. Mr. Speaker, a number of members have raised the issue about a Māori Land Service, and I know that it's not in this particular part. Suffice to say that that is still being built, and any conjecture with respect to the appointments of chief executives, etc., are a little bit early, but we can come to that later on in the discussion. I hope that's been helpful to members.
Mr. Chair.
Matt Ducey.
I move that the question be now put. Mr. Ducey, it's really unusual to do that after your own side just had a call. It's an indication of lack of confidence in the minister, and I don't think you really meant it.
Mr. Chair.
Lewis Award.
Talofa lava, Mr. Chair.